Almost 20 years ago, in the year of 2002, when the state of Gujarat was rocked with riots and violence, Bilkis Bano was gang raped by 11 men. Her infant child was killed in front of her eyes, and while she was being gang raped, she was also pregnant. In fact, 7 of her family members too had to face the brunt and died in front of Bilkis' eyes. Very recently, last year, the Supreme Court had in fact started hearing a petition by Bilkis Bano challenging a remission that was granted to the 11 convicts in this particular case. A remission that was granted by the Gujarat government was challenged before, in fact, the Supreme Court of India. The Supreme Court started to hear that particular matter and delivered a judgment yesterday. The Supreme Court very clearly and categorically stated in its order yesterday that the judgment of May 2022, wherein it was decided that the Gujarat government's policy would apply, is wrong because these convicts had approached the Supreme Court with wrong hands, with unclean hands. Not only this, the Supreme Court went on to say that the Gujarat government is not the appropriate government which should have decided this particular remission applications. In fact, it was the state of Maharashtra, because as per the Code of Criminal Procedure, the procedure would apply only to the state where a particular trial and sentencing had taken place. And in this case, this was the state of Maharashtra, because the Supreme Court has transferred the trial in this particular case from Gujarat to Maharashtra after noting the collusion of the state with convicts. Now, the Supreme Court also went down heavily on, in fact, the arbitrary orders passed by the earlier courts, and very categorically stated that it bears the beacon to correct the arbitrariness in the law, since it is the first court in the country. But today we are here to know as to what lies ahead for these 11 convicts in this particular case. What is their fate? Will they be going back to the jail or not? And will they be able to come out again or not? But first of all, these convicts have to surrender before the Gujarat prison within 2 weeks, is what the Supreme Court has said. And it is the state of Maharashtra's policy which will now be applying on them if at all they want to seek a remission in this particular case. But the case here is a bit different. The state of Maharashtra's remission policies are a little stringent, and there might be any relief that might come in for them before 2030 or 2036. Now, what does the remission policy of Maharashtra says? So, there exist 2 remission policies in the state of Maharashtra. One is the latest policy that is there for 2008, and another one is with regards to a 1992 policy. If at all the 1992 policy apply, people who have undergone imprisonment of over 22 years, then only can they apply for a remission in a case that involves sexual offences, that involves murder or heinous crimes. While if you go by the 2008 policy, which becomes a much more stringent one, before 28 years, no kind of a remission can actually be granted until and unless a person actually goes through an imprisonment of 28 years, which is 8 years more than the 1992 policy. So there is no kind of a relief coming in for these convicts until 2030 or 2036. So definitely they have to be in the jail for at least some more years now, and the remission applications might have their fate only when applied for by these convicts, and that is a matter of time. We'll get to know when these convicts actually approach the remission authorities to actually seek a remission in this particular case. Not only this, they can also challenge this order before the Supreme Court of India in a review petition, but will that happen or not is something a matter of time.